Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us today's online talk entitled Medical Negligence Claims in Malaysia, a Guide for Foreign Patients. My name is Edwin Raj. I am a Senior Associate with Mawing Kwai & Associates, and I will be your moderator for today's session. Now, before we start today's talk, let me introduce the firm and what we do. Mawing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Dato' Mawing Kwai. Our able team today comprises 37 lawyers and a support team of 29. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. Our services: we are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment, industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our Mawing Kwai online talk series, and by way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcast live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, we have two speakers for today. Allow me to first introduce our first speaker, Jason Lim. Jason admitted to the Malaysian bar in 2021, and he has a Bachelor of Laws from Queen's University, Belfast. He's an associate in our Medical and Personal Injury Department, and his areas of practice includes medical negligence, personal injury, occupiers liability, and general litigation. Our second speaker for today, Ms. Elisa Noor Suraya, is also an associate in our Dispute Resolution Department. She has a Bachelor of Laws in National University of Malaya, and she was admitted to the High Court of Malaya this year in 2024. Her areas of practice includes medical law, personal injury cases, and employment law. We have a total of 4 talk points The first speaker, Jason Lim, will cover the first two talk points, and the last two talk points will be covered by our second speaker, Ms. Elisa Noor Suraya. I will leave it to Jason to take over the floor.
Thank you, Edwin. Thank you, everyone, for joining us today. So to start off today's session, I thought it would be fitting to share with everyone an overview of Malaysia's healthcare services from the perspective of a foreign patient. So Malaysia's healthcare services have increasingly become a global hub for medical tourism, recording over 1 million health tourist arrivals in 2023 alone. With its combination of high standards and affordable prices, the country has attracted patients from around the world, including Singapore, China, Australia, the United Kingdom, and the USA. However, as in any medical system, error and mistakes can happen, sometimes with devastating consequences for patients. This has led to a growing awareness of patients' rights and an increasing trend of damages awarded by the Malaysian courts. Foreigners who have received negligent medical treatment in Malaysia have the right to bring claims in Malaysian courts to seek compensation or redress for the injuries, losses, and damages that they have suffered. However, for foreign patients, navigating the complexities of a medical negligence claim in an often unfamiliar legal system can be quite overwhelming. Many are often unsure where to begin, whom to contact, or even how to proceed. Today's session is designed to shed light on these issues, offering practical guidance to help foreign patients understand their rights and the steps they can do to pursue justice and fair compensation. Let me now proceed by sharing with everyone a real-life example of a foreign patient who has pursued a medical negligence claim here in Malaysia. Henry was a 22-year-old Myanmar refugee who was alleged to be assaulted by a group of people in Cheras, Kuala Lumpur on Christmas Eve in 2010. Henry arrived in Malaysia and his wife, together with his wife, as refugees and was employed as an odd job worker. At the time of the incident, his wife was pregnant, had left to be resettled in the United States. Henry was to have left Malaysia on Christmas Day, the day after, together with his wife to start a new life. However, as a result of the assault, Henry suffered injuries around his face and mouth, including intraoral soft tissues injuries and fracture of the mandible. Henry was later brought to the emergency department of a university-owned hospital for treatment. Unfortunately, Henry was administered 5 times the intended dosage of an anesthetic drug, ketamine, to sedate the patient in order to proceed with surgery to repair his soft tissues injuries. And as a result, Henry suffered bradycardia and ultimately cardiac arrest. Henry later suffered some other complications, including renal failure and sepsis, and was diagnosed later to have suffered permanent brain damage and other permanent injuries. Henry was discharged from the hospital in January 2011. Henry remains in Malaysia in a vegetative state and is cared for by a charitable organization. When the High Court heard Henry's claim in 2019, the High Court awarded approximately 784,000 in damages and costs. This was later increased by the Court of Appeal to approximately 1.7 million, excluding interest, in 2020. So having looked at an example of a medical negligence claim brought by a foreign patient in Malaysia, we now looked into what exactly constitutes medical negligence. In essence, medical negligence concerns with the tort of negligence in the provision of healthcare. Pursuing a medical negligence claim can often and is often far more of a challenging experience for litigant as compared to pursuing an ordinary personal injury negligence claim, such as those arising from motor vehicle incidents. We will now discuss the procedural aspects of a medical negligence claim in Malaysia and also some of the practical challenges that are inherent in this area of law. So when we come to the elements for negligence, in essence, there are 4 main elements to be proven to succeed in a claim for negligence. First, there is to prove that there is a duty of care. The law is tried in this area that there is a duty of care that arises from a doctor-patient relationship. Second, there is a breach of duty of care or a failure to conform to that standard of care. And the patient must also prove whether the doctor has fallen below the standard of care in the course of treatment. The third element is causation, that the duty of care, breach of duty of care caused damage to the patient. So the first step to any medical negligence claim is often to seek for medical records from the relevant hospitals, both treating and also negligent hospital. This is because patients' medical records are often the best evidence of matters relating to diagnosis, treatment, consent, and the provision of advice and information to patients, all of which are relevant issues in medical negligence claims. So what exactly constitute medical records? This is a non-exhaustive list provided by the Malaysian Medical Council guidelines. So it can range from ICU notes, doctor notes, clinical notes, if there's charts, images taken, those are all constitutes medical records. So the law is tried that patients are entitled to access their medical records for a wide ranging of reasons, whether to seek medical opinion, to obtain further treatment, to get better understanding of their illness, or even to determine whether they have a meritorious case prior to commencing a legal suit for medical negligence. In regards to disclosure of medical records, the court in Nurul Husna has held that ownership of a patient's medical records lies with the physician or hospital, but with the patient's best interest in mind. And the doctor or hospital has a corresponding general duty to disclose the medical records to the patients. The MMC also encourages the disclosure of medical records unless the disclosure may be detrimental to the patient or any other individual, or liable to cause serious harm to the patient's mental or physical or endanger his life, or that there's no consent given by the patient or their next of kin. Despite the tried law that patients have and are entitled to their medical records, it is often difficult to obtain medical records due to various barriers in place. Often, the hospital refuses access to medical records on grounds that documents they requested are not relevant, they are confidential and or privileged, or sometimes hospital only agree to disclose medical records with the condition that a court order is required. So this process of getting medical records is not as easy as straightforward, because in practice, hospitals or doctors may refuse such requests unless there is a court order. So what happens if the hospitals or doctors refuse access to medical records? The prudent step would be to file a pre-action discovery application under Order 24, Rule 7A of the Rules of Court through solicitors. The court will also consider, when pre-action discovery is made, if the hospital or doctors give unreasonable denial of access or difficulties in accessing medical records. This will often lead to the hospital being penalized in costs or a higher award for aggravated damages. Now, when it comes to limitation period, before we continue on limitation period, it's prudent when it comes to limitation period to always seek legal advice and not attempt to calculate limitation period yourself, because the law governing limitation for medical negligence claims, especially in Malaysia, is complex and multifaceted. There are various statutory provisions which provides for different limitation periods for a civil claim in Malaysia. And the applicable limitation period for a particular medical negligence claim is determined by various factors, including the status of the patient, namely whether the patient is alive or deceased, and whether they are under any form of disability. The limitation period also is affected when the identity of defendants and the geographical region where the cause of action arose. So in general, if there is a claim against government hospitals or clinics, limitation starts to run 36 months from the date of the Tortious Act. And if the claim is brought against private healthcare facilities and service providers, the limitation period is 6 years from the date of which the plaintiff suffers damage or injury. Just to provide some examples of how the limitation period will vary is, for example, where a patient is under a disability. What do we mean by disability? A patient can be deemed disabled either by reason of them being a minor, which is under 18 years old, or them being of unsound mind. For example, if a child will have 6 years from the date they attain the age of majority, which is 18, to sue for any medical negligent treatment they receive as a child at a private healthcare facility. Another example is a patient who falls into a coma as a result of negligent treatment in a private healthcare facility will have 6 years from the date they recover from the coma to sue for such negligent treatment. Another example is in regards to a deceased patient. When a patient dies as a result of negligent treatment, the patient's dependents or personal representatives of the deceased patient's estate may bring a claim within 3 years from the date of the patient's death. So these are just some of the common examples for limitation period, but again, limitation period will vary very much and dependent on the facts, individual facts of the case. So again, in regards to limitation period, always seek a legal professional advice and don't attempt to calculate a limitation period, because once a limitation period is missed, it may be detrimental to the case. The next aspect of medical negligence claim is in regards to an expert opinion. As mentioned previously, one of the essential elements for a medical negligence claim is to prove a breach of duty on the part of a negligent doctor, i.e. proving that the doctor has fallen below the standard of care expected of a reasonably competent medical professional in the position of the defendant. This would often require the plaintiff to present and the courts to evaluate information and material relating to principles of medical science and practice. Such an exercise would be impossible for the plaintiff, their legal representatives, or the judge hearing the case, by virtue of the fact that many often lack medical training and knowledge. It is in this context that expert witnesses play a vital role in assisting the court in determining and deciding medical negligence claim. So what exactly is an expert opinion? An expert opinion is a document provided by a medical practitioner based on medical records of patients, and it often would address the point of whether or not there is negligence on the part of the hospitals or the doctors involved. And who prepares an expert opinion? It will often be an independent medical practitioner with relevant expertise. And the expert doctor has to be independent, which means that the expert doctor cannot be involved in the previous treatment or management of the patient involved. So the question comes, why is an expert opinion required? And an expert opinion is often required to assist the court in understanding the case better and to assess whether there is negligence on the part of a medical practitioner who treated. Often the court has placed a very heavy reliance on independent expert evidence when deciding medical negligence claims. Expert evidence is not just relevant towards proving breach of duty, it is also crucial in determining causation, prognosis, and future care needs of the patient for the purposes of assessing quantum and damages to be awarded. The plaintiff's failure to adduce expert evidence in court to support their claim, although not always necessary, it would sometimes prove to be fatal to a plaintiff's claim. In some instances, different experts may be required for liability and quantum for damages. For example, in a case involving a child suffering catastrophic brain damage due to events occurring during birth, experts in the field of obstetric and/or neonatology would have to be instructed on the issue of liability, while experts in rehab medicine and/or pediatric neurology would have to be instructed to advise on the child's prognosis and future care needs to assist the court with making a decision on the quantum of damages in the event negligence is found. A unique aspect of a medical negligence claim when foreign patients is involved is security for cause. When a plaintiff that is filing an action is out of jurisdiction, the defendant may apply to court for an order that the plaintiff pays a certain sum as security for the defendant's cause pursuant to Order 23 of the Rules of Court 2012. This is so that in the event that the plaintiff loses its case, the plaintiff has already a sum of money deposited in courts. So this is a unique feature that is required when a foreign patient files a claim in Malaysian courts. So with that, I'll pass it on to my colleague, Elisandro. Thank you.
Thank you, Mr. Jason. So now we will delve into the area of damages in medical negligence claims. So what are damages generally? In legal terms, damages refer to monetary award granted to compensate an individual for losses or injuries sustained. The overarching principle of such damages is that damages must be compensatory in nature. This principle is actually well established in the case law of Livingstone against Royals, 1880, where the court stated where any injury is to be compensated by damages, you should as nearly as possible arrive at the sum of money which will put the injured party in the same position as they would have been in if they had not sustained the wrong. In the medical negligence claim, once a claimant successfully proves liability against the tortfeasor, the court then moves to address the issue of damages. When awarding damages, the court endeavors to calculate a reasonable sum that reflects the injury sustained, the loss occurred, and the harm suffered as the result of the negligent treatment and/or management. So the assessment of quantum in medical negligent cases is often complex and depends significantly on, amongst others, the nature and severity of the injury. For instance, if the negligence results in catastrophic or lifelong injuries, the damages awarded will likely be substantial to cover the long-term care and diminish quality of life. Conversely, if the negligence results in a minor or temporary injury, the damages awarded will generally be lower. So ultimately, the assessment of damages here requires careful consideration of the specific circumstances of each case, ensuring that the compensation here is awarded fairly and justly. So in awarding damages, the court considers the heads of damages pleaded and proven during the trial. Each category of damages is assessed individually to ensure the compensation awarded is fair and just. So these categories are namely the special damages, which cover actual quantifiable losses such as medical expenses and loss of income, general damages, which accounts for non-quantifiable harm, including pain, suffering, and loss of amenities. Future damages, which are compensation for anticipated future losses, such as ongoing medical care or long-term rehabilitation costs. Aggravated damages, which is a separate category awarded when the defendant's conduct was particularly outstandingly bad, which causes additional emotional distress to the plaintiff. Costs, which are reimbursement for the legal expenses incurred by the successful party, and interest, which is compensation for the time delay in receiving damages calculated from the date of the injury or loss. So for the purpose of this talk, I will further explain on only 4 categories, which are special damages, general damages, future damages, and aggravated damages. Here, we need to keep in mind that the ultimate aim for damages is to ensure that the awarded damages adequately compensate the plaintiff for the injuries, losses, and harm suffered due to the defendant's negligence, and not to enrich the plaintiff. Now that we have a general understanding on damages, let us turn to the special damages, which focus on the specific quantifiable losses incurred by the plaintiff. So special damages are quantifiable in monetary terms. These include medical expenses, transportation costs, loss of earnings, or any other financial burden directly linked to the negligent act. As a general rule, all expenses or losses incurred are recoverable, provided that they are justifiable under the circumstances and within a reasonable sum. However, it is crucial to note that the special damages must be specifically pleaded and particularized in the claim, and also proven through oral or documentary evidence. This requirement to prove these special damages via oral or documentary evidence is actually challenging, as particularly in cases where you need receipts or other documentation, but it's unavailable. So courts do acknowledge these circumstances and have recognized that it is unrealistic to expect all the plaintiffs to have a complete full set of receipts for each and every expense that you have incurred. Oral testimony can also suffice to prove these expenses if they are reasonably expected to have been incurred. Special damages can also be categorized into 2 periods. So you can claim special damages from the date of negligence to the date of filing of the writ, and also during the special damages incurred during pre-trial period. So for the first one, these damages encompass the losses incurred from the time the negligent act occurred until the filing of the writ. So this includes and is not limited to medical expenses such as costs for treatments, medications, and consultations directly resulting from the negligence, and also your loss of earnings, which is the loss of income during this period due to your inability to work as a result of the injuries that you have sustained due to the negligence. As for the pre-trial period, this category covers the period from the filing of the writ until the trial commences. So it also accounts for the continued medical expenses, where any further costs for ongoing treatments, therapies, or follow-ups, which is resulted by the Negligent Act, is also covered, and also any other loss of earnings, as well as other expenses, which includes transportation to medical facilities, additional care or support, or any other quantifiable expenses. Now let's move on to general damages, which is different from special damages as they are not capable of being precisely calculated. General damages, in essential, it is awarded to compensate for losses or injuries that are not quantifiable. So this includes pain and suffering and loss of amenities, which is for if it's pain and suffering, it's focused on physical pain and emotional distress caused by the injury. And as for loss of amenities, it's regarding the diminished ability for a patient to enjoy life due to physical or psychological injury. So unlike pain and suffering, this component of loss of amenities compensates for the loss of the plaintiff's ability to itself. So regardless of whether or not the plaintiff is aware of it, is still under loss of amenities. Next is value of care. Value of care is compensation for the care provided to the patient as a result of the injury. As you can see, both of these are definitely not quantifiable and it falls under general damages. So how does court assess general damages? The court determines the amount to be awarded for general damages by considering several factors. So firstly, the court considers comparable or precedent cases. So the court may refer to prior decisions which involve similar injuries to guide the quantum of damages. Aside from that, you can also see there's Compendium of Personal Injury Awards, where it is published by the Malaysian Bar Council, where it is actually a guideline for injuries, orthopedic injuries. However, the court is not bound by it and may depart from it based on the circumstances of each case and the unique facts of each case. Next, the court can also refer to the medical evidence, which are usually testimonies and reports from medical experts, which really often play a crucial role in assessing the extent of the injury and its impact on the plaintiff's life. So the key factors considered by court in awarding general damages is usually the court will examine the plaintiff's lifestyle before the negligence occurred and how did it change after the negligence occurred. And next, the court will also see the nature and extent of injury, including any permanent disabilities due to that negligence. The court will also see the number and type of remedial procedures that the plaintiff requires. Next, the court will also consider the recovery period and the risk of future deterioration. And they will also see personal factors such as the plaintiff's age, your gender, marital status, and also your employment. So we can see here that general damages aim to fairly compensate the plaintiff for the pain and suffering and loss of quality life caused by a negligence. So here we've covered general damages. Let's move on to future damages. So future damages essentially are an extension of general damages and compensate for the potential long-term impact of injuries. Hence, it is also unquantifiable. Future damages are assessed on a once and for all basis, meaning the courts provide a single lump sum award where the victim cannot return to court later to claim more damages, even if your condition worsens or a new needs arise. In the case of Nurul Husna, 2015, the court emphasized this principle, where the judgment highlighted that future damages are based on logical analysis of expert opinions, ensuring that the award is reasonable and well-informed. Furthermore, we can also see in the case of MediCircle 2022, where the court stated that the future damages must be supported by a substantial likelihood of occurrence and not mere speculation. All claims, you cannot just simply bring speculative claims. All claims must be based on realistic risks, possibilities, or the real dangers of future losses. The court will usually award future damages based on evidence and precedents. So expert evidence may also be referred to when deciding on future damages, as some expert evidence will show the future loss or expenses that may occur or be incurred by the patient itself, or the likelihood of required medicines or treatments that may be required by the patient in the future. So to sum it up, the courts will consider the likelihood of future losses and also will avoid speculative claims. So by balancing these considerations, the court will itself provide fair and adequate compensation for the plaintiffs. Next is aggravated damages. Aggravated damages serves as compensation for the plaintiff's injured feelings. So these aggravated damages aims to address the distress, indignity, or emotional harm caused by the defendant's conduct over and above the physical or financial losses as the three previous categories of damages that I have explained previously. So in the case of Dr. Hari Krishnan, the federal court emphasized that aggravated damages can be awarded as a separate head of damages, where in the judgment of the federal court, it was highlighted that in appropriate cases, substantial damages may be awarded for any indignity, discomfort, or inconvenience suffered, and even aggravated damages may be awarded in light of the conduct of the tortfeasor. So here, Malaysian courts have recognized this form of aggravated damages in several cases where defendants' actions have exacerbated the plaintiff's suffering. So a few examples we have laid down here in the slides. One of them are insolent behavior of the medical practitioner towards the patient and their family, causing distress or anxiety. Next, negative conduct displayed throughout the trial, such as hostility or dishonesty. Thirdly is the failure to follow hospital guidelines, which it results in harm or aggravation of the plaintiff's injuries. And fifth is providing inaccurate information or being dishonest in medical documentation, and also like suppress the patient's medical records when the plaintiff actually applies for the medical records. This actually creates additional emotional trauma and delays justice. So these are included under aggravated damages. So in short, aggravated damages are pertaining conduct that worsens the harm suffered by the patient or even their family members. So with that, we've covered 4 categories of damages, which are general, future, special, and aggravated damages. So each of these damages serve a distinct purpose, ensuring the plaintiff is fairly compensated for the harm they have suffered, whether it be physical, financial, or even emotional. So now it is important to note that in any medical negligence claim, engaging a lawyer early in the process can significantly strengthen your case, because lawyers play a critical role not only during court proceedings but also in the preliminary stages, because your lawyers can assist to advise on the grounds or merits of the claim, assist with negotiations with the other party, or in the event that negotiations have failed, file a claim in court. Legal assistance is important in gathering evidence, engaging with relevant parties involved, and advising on legal options before the matter escalates to litigation. So here it is clear that the early intervention really increases your chances to achieve a fair and efficient resolution. To sum it up, understanding the types of damages available and the importance of early legal involvement is very crucial in navigating a medical negligence claim, especially for foreign patients. Each step, whether identifying the harm suffered, quantifying the damages, or engaging legal assistance, forms a part of broader strategy for yourself to ensure justice is served. So now I pass the floor to my colleague, Mr. Edwin.
Thank you, Jason and Elisa, for your insights in medical negligence claims in Malaysia, a guide for foreign patients. We will now take questions from the participants from the Q&A chat box. There are a few questions from the audience. Perhaps just let me read them out. The first question is, can we get the slides for the talk? Yes, the slides shall be made available through our website following the conclusion of this talk. The second question that we have is, can I get copies of the medical records on my own without a lawyer? Jason, perhaps you can take this question.
Sure. The short answer to that is yes, you may be able to write in yourself to get the medical records. However, in our experience, patients will often face difficulties we're going through the usual channels to get such documents. Law firms with experience in medical legal litigation will have less difficulty and also be in a better position to identify, for example, missing records, notice suspicious entries, and etc. For a layperson looking at medical records for the first time, it may pose a challenge, and that's why we would recommend for you to go through your solicitors to get medical records for you.
Thank you, Jason. Now, the next question we have is, what if a patient doesn't keep the documents for expenses or special damages? Are they still able to claim for these expenses or losses? Elisa, would you like to take this?
So for this question, yes, you can still claim for these special damages or expenses, because provided that the expenses are reasonable, the court have really previously accepted that claimants are not expected to behave like bookkeepers in keeping bills and receipts. So in one particular case, which is Farid Rizal's case, the Court of Appeal allowed a claim for loss of earnings despite the lack of income documents, because there was no other evidence to support the claim, including oral evidence from witnesses and company statements where the patient owned more than 90% of the shares. To answer your question, yes, they can still claim.
Thanks, Elisa. Now, your talk featured a lot about a guide to foreign patients in navigating medical negligence, but can I understand, in a situation, how do patients know if there's a possibility of negligence? Because often and not, we get situations where the patients are completely unaware or unsure. So perhaps you can give a perspective on that, Jason?
It really depends, because in some cases, negligence may be obvious. For example, there are retained products during surgery, or even there's a clear failure to diagnose an obvious condition. But on the other hand, there are cases where negligence are not as clear-cut or would require assessment, for example, through an independent expert of the relevant specialty. Therefore, that patients who wish to be more certain and to be aware of the merits of a case, to engage a lawyer that has sufficient experience undertaking medical legal cases, and in engaging independent experts to obtain the records first. Second is to review the records and also to advise them accordingly later.
Thank you, Jason. The next question is, we are aware that the past or the recent few cases, the court has shifted a little on awarding multi-million for these cases and is reported everywhere in the news. What are your thoughts, Elisa?
Yeah, this is quite a complicated question, but I will attempt to answer. Yes, recent judgment includes the most recent is the 9 million judgment against a government hospital involving an infant with brain injuries, had certainly made some waves. However, it must be noted that such judgments are often the result of damages awarded for a patient's future treatment, which is often premised on expert evidence that is scrutinized by the courts. So the basis is often clear and with cogent medical evidence that is gone through by the judge, sometimes at multiple levels of the court system itself. So with the ongoing developments in technology and medicine, as well as the rising of medical costs, obviously, it is unsurprising that such issues are reflected in expert recommendations and evidence. And this results in the court awarding damages for the patient. And that being said, the damages awarded in any case is based on the circumstances and the facts of each case, and also the patient itself. Just like I mentioned just now, the injury sustained by the patient and the loss incurred by the patient. It takes into account a number of factors.
Thanks, Elisa, for your perspective on this quite challenging question. Jason, can I give the next question to you? One of our attendees asked a question, although I think you have covered this, but perhaps you can just re-highlight what constitutes medical negligence under Malaysian law, and what are the steps for filing a medical negligence claim in Malaysia? Jason?
Okay, yeah, essentially to summarize, there are three basic steps to proving medical negligence. First, you have to prove that there is a duty of care. This is usually established through a patient-doctor relationship. Second is that doctor breached their duty of care by virtue of negligent treatment. And thirdly, that such breach of the negligent treatment has caused or materially contributed to the injuries suffered by the patient. And the negligent treatment is usually proven by way of expert evidence. When it comes to the steps, the usual course initially would be to get access to the medical records. Once we get access to the medical records, we get them assessed by a medical expert. And then following the assessment of the claim is prepared, and then we will proceed with filing the claim in court by filing the writ and also the statement of claim.
Thank you, Jason. There's another question. Would you file the pre-action discovery against the hospital or MMA if there's an inquiry carried out in a medical negligence with the hope of finding proof? This, I will leave it to Jason again because I think you spoke on pre-action discovery earlier. Jason?
Sure. It is common to file a pre-action discovery against the owners and managers of hospitals to obtain copies of medical records. If there is an inquiry at the hospital, for example, you may seek pre-action discovery of such internal inquiry documents. There are authorities to show that these documents, the internal inquiry documents, are discoverable. However, most hospitals oppose discoveries of such documents, and a contested hearing with counsel submitting on the law is usually required to obtain such documents.
Thank you, Jason, once again. 2 questions in a row. Maybe we'll take a final question. Can out-of-court settlement be pursued in such cases? And how often are they successful? Elisa, you want to take this up?
Yes, sure. Generally, yes, they can be pursued. In our experience, the majority of medical cases are often settled. However, the likelihood itself for settlement depends on every case because, as we previously mentioned, different cases have different circumstances, different injuries.
Okay, thank you. I think we have a few more questions. Unfortunately, due to time constraints, we are unable to answer them here, but don't worry. You can always reach out to us after the conclusion of this talk as well. Before we conclude this, allow me to just share with you. I have a few announcements to make. First, thank you, and please join us again for our upcoming talk, From Judgment to Justice, Navigating Execution Proceedings, by our very own speakers, Elisa Dalila and Amanda Pond. The date is, as stated in the slides, 18th of December, 2024, Wednesday. You can sign up through this website. Secondly, please fill in our feedback form and tell us what you thought about our talk. The link in the form will be posted in the chat. Please follow our social media accounts, which are available at your screens. Fourthly, if you'd like to speak with our lawyers, we offer a complimentary consultation up to a 30-minute over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box as well. Finally, to our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody. And once again, see you at our next talk.